What if I told you that a document exists, signed by a United States attorney, filed in a federal courthouse, that granted criminal immunity not only to a serial child sex offender, but to anyone who helped him? Not a pardon, not a verdict, an agreement, drafted in secret, signed in secret, and hidden from the very victims the law was supposed to protect. The document is called the Non-Prosecution Agreement. It was executed on September 24, 2007, and a federal judge would later rule that its very existence violated federal law. Stay till the end, because the language buried inside this agreement doesn't just protect one man, it protects everyone around him. And the phrase that does it is only 4 words long. I'm Mark Epstein, and this is the Epstein Files. September 2007. The United States Attorney's Office for the Southern District of Florida. The man in charge is R. Alexander Acosta, appointed U.S. Attorney by President George W. Bush in 2005. For more than a year, federal agents from the FBI's Miami field office have been investigating Jeffrey Edward Epstein, building a case that began where the Palm Beach Police Department's investigation left off. Palm Beach Police Chief Michael Ryder, frustrated with Palm Beach County State Attorney Barry Krischer's decision to pursue only a single solicitation charge, had taken the extraordinary step of referring the case directly to the FBI in 2006. The FBI investigation was substantial. Agents identified over 36 victims. They compiled flight records. They reviewed financial transactions. And an assistant United States attorney named Anne Marie Villafana prepared a federal indictment, a detailed, multi-count charging document that would have brought federal sex trafficking charges against Jeffrey Epstein. That indictment was never filed. Instead, what emerged was a document unlike anything seasoned federal prosecutors had ever seen. A non-prosecution agreement so favorable to the defendant that legal scholars, federal judges, and even the Department of Justice's own Office of Professional Responsibility would spend years trying to understand how it happened. But here's where it gets disturbing. To understand the NPA, you have to understand what Epstein was facing and what he assembled to fight it. The FBI's investigation had produced a case strong enough to support federal charges, including sex trafficking of minors under Title 18, United States Code, Sections 1591, and related statutes. Over 3 dozen identified victims. Physical evidence recovered during the October 2005 search of 358 El Brillo Way in Palm Beach. Corroborating testimony from household employees. Flight records. Financial records. AUSA Villafana had the case. In response, Jeffrey Epstein assembled what may be the most formidable criminal defense team ever constructed for a single defendant. His attorneys included Jack Goldberger, a prominent Palm Beach criminal defense lawyer; Kenneth Starr, the former independent counsel who had investigated President Bill Clinton; Alan Dershowitz, Harvard Law School professor and one of the most recognized appellate lawyers in the country; Jay Lefkowitz, a former special envoy for human rights under the Bush administration; Gerald Lefcourt, a veteran New York criminal defense attorney; Martin Weinberg, a Boston-based trial attorney; and Guy Lewis, a former United States attorney himself. This was not a legal team. This was an army. And their strategy, as documented in subsequent court filings and reporting, was not merely to defend Epstein at trial. It was to prevent a trial from ever happening. According to the Miami Herald's investigation and subsequent court filings in Case 808-80736 CIV in the Southern District of Florida, Epstein's attorneys engaged in extensive communications with the U.S. Attorney's Office, including direct contact with U.S. Attorney Acosta. A key meeting reportedly took place in October 2007 at a hotel in West Palm Beach between Acosta and Jay Lefkowitz, during which the framework of the agreement was discussed. Source: Miami Herald. Perversion of Justice. Part 2. Victim filings in Case 808-80736 CIV. DOJ OPR Report, November 2020. The negotiations resulted in the Non-Prosecution Agreement, executed on September 24, 2007. Source: Pacer, NPA document filed in case 08-80736 CIV, document cloud, NPA, full text. Here is what that agreement said. Under the NPA, the federal government agreed not to prosecute Jeffrey Epstein on federal charges. In exchange, Epstein would plead guilty to 2 state charges in Palm Beach County. 1 count of solicitation of prostitution, and 1 count of procurement of minors for prostitution. A felony, but far below what federal sex trafficking charges would have carried. He would be required to register as a sex offender, and he would serve 18 months in the Palm Beach County Stockade. Source: NPA document, September 24, 2007, Pacer, case 08-80736, CIV, Palm Beach County Circuit Court records. 18 months in county jail, not federal prison, for crimes that, if prosecuted federally, could have resulted in a sentence of life imprisonment under federal sex trafficking statutes. Now, if you're still here, it means you can handle the truth. So let me show you what they didn't want you to see. The sentencing terms were extraordinary on their own. But the most consequential language in the Non-Prosecution Agreement was not about Jeffrey Epstein at all. It was about everyone else. The NPA contained a clause. And I want you to listen carefully to this language, in which the United States Attorney's Office agreed that it would not institute any criminal charges against any potential co-conspirators of Epstein. The agreement then listed specific names, including Sarah Kellen, Adriana Ross, Leslie Groff, and Nadia Marcinkova. Source: NPA document, September 24, 2007, Co-Conspirator Immunity Clause. Pacer, case 08-80736 CIV, Miami Herald, Perversion of Justice, Part 3. But it did not stop there. The critical phrase, the 4 words I mentioned at the beginning of this episode, read, including but not limited to. Source: NPA full text, document cloud, Pacer, case 08-80736 CIV. Including but not limited to. That phrase transformed this agreement from a plea deal for one man into a blanket shield of federal immunity for an undefined, open-ended group of people connected to Epstein's operation. Anyone who could be classified as a potential co-conspirator, named or unnamed, was protected. The scope of that immunity was, by its own language, unlimited. Legal scholars have pointed to this clause as virtually unprecedented in federal criminal practice. The question it raises is not subtle. Who, specifically, was this clause designed to protect? And why would a United States attorney agree to immunize people whose identities and roles had not yet been fully investigated? And there was another provision that made this agreement extraordinary. The NPA was kept secret from the victims. Source: Judge Kenneth Mara ruling, February 21, 2019. Case 808-80736 CIV, Miami Herald, Perversion of Justice. Under the Crime Victims' Rights Act, Title 18, United States Code, Section 3771, enacted by Congress in 2004, crime victims have the right to be reasonably informed of any plea bargain or deferred prosecution agreement. They have the right to confer with the government's attorney. They have the right to be heard. Source: ICIN USC, Parágrafo 3771, Pacer, Case 08-80736, CIV, Judge Mara ruling. None of this happened. The victims in this case, teenage girls who had been sexually abused, were not told about the NPA before it was signed. They were not consulted. They were not given the opportunity to object. According to court filings, some victims were actively misled. Correspondence from the U.S. Attorney's Office to victims' attorneys suggested the investigation was ongoing. At the same time, the NPA was being finalized behind closed doors. Source: Pacer, Case 08-80736, CIV, Victim Filings, Exhibits A through F, Miami Herald, Perversion of Justice, Part 3, Judge Mara, ruling, February 21, 2019. This is where the official story falls apart. That phrase transformed this agreement from a plea deal for one man into a blanket shield of federal immunity for an undefined, open-ended group of people connected to Epstein's operation. Anyone who could be classified as a potential co-conspirator, named or unnamed, was protected. The scope of that immunity was, by its own language, unlimited. Legal scholars have pointed to this clause as virtually unprecedented in federal criminal practice. The question it raises is not subtle. Who, specifically, was this clause designed to protect? And why would a United States attorney agree to immunize people whose identities and roles had not yet been fully investigated? And there was another provision that made this agreement extraordinary. The NPA was kept secret from the victims. Under the Crime Victims' Rights Act, Title 18, United States Code, Section 3771, enacted by Congress in 2004, crime victims have the right to be reasonably informed of any plea bargain or deferred prosecution agreement. They have the right to confer with the government's attorney. They have the right to be heard. None of this happened. Pause. The victims in this case, teenage girls who had been sexually abused, were not told about the NPA before it was signed. They were not consulted. They were not given the opportunity to object. According to court filings, some victims were actively misled. Correspondence from the U.S. Attorney's Office to victims' attorneys suggested the investigation was ongoing. At the same time, the NPA was being finalized behind closed doors. This is where the official story falls apart. In 2008, attorneys Paul Cassell, a former federal judge and law professor at the University of Utah S.J. Quinney College of Law, and Bradley Edwards, a Fort Lauderdale-based victims' rights attorney, filed a lawsuit on behalf of two victims, identified as Jane Doe 1 and Jane Doe 2. Their claim was direct. The United States government violated the Crime Victims' Rights Act when it concealed the Non-Prosecution Agreement from Epstein's victims. That case would take more than a decade to resolve. On February 21, 2019, United States District Judge Kenneth Mara issued his ruling. He found that the government had indeed violated the Crime Victims' Rights Act. The NPA had been negotiated and executed without the knowledge or consent of the victims, in direct contravention of federal law. Judge Mara's ruling was a landmark. It confirmed in a federal court order that the most powerful law enforcement apparatus in the world had broken its own rules, not to pursue justice, but to quietly close a case involving the serial sexual abuse of children. But by the time that ruling came, the damage was done. Epstein had pleaded guilty to the state charges in June 2008. He reported to the Palm Beach County Stockade to begin his 18-month sentence. But even the terms of that sentence were undermined. The Palm Beach County Sheriff's Office granted Epstein a work release program, allowing him to leave the stockade 6 days a week, up to 12 hours a day, to travel to a private office in West Palm Beach. He served approximately 13 months before being released in July 2009. 13 months, work release, for over 36 identified victims. And the co-conspirators named in the NPA, the assistants who scheduled the so-called massages, the associates who participated in recruiting and transporting minors, they were never federally charged under that agreement. The clause protected them. The 4 words shielded them, including but not limited to. The broader implications ripple throughout this entire series. Alexander Acosta left the U.S. Attorney's Office and was later nominated by President Donald Trump to serve as United States Secretary of Labor in 2017. During his confirmation hearing before the Senate Health, Education, Labor and Pensions Committee, Acosta was questioned about the Epstein NPA. He defended the agreement, stating that without it, Epstein might have received no jail time at all. When the Miami Herald published Julie K. Brown's Perversion of Justice series beginning in November 2018, the full scope of the NPA's terms became widely known to the public for the first time. The resulting outcry contributed to Acosta's resignation as Secretary of Labor on July 19, 2019. In November 2020, the Department of Justice's Office of Professional Responsibility released its review of Acosta's handling of the Epstein case. The OPR concluded that Acosta had exercised poor judgment in several respects, but did not find that he had committed professional misconduct. Poor judgment, that is the official finding, for an agreement that immunized unnamed co-conspirators, concealed a plea deal from child victims, and ensured that a man who sexually abused over 36 minors served 13 months in a county jail with work release privileges. Poor judgment. The questions this episode leaves unanswered are not rhetorical, they are structural. Who approved the inclusion of the including but not limited to language? And at whose request? Which co-conspirators, beyond those specifically named, benefited from that clause? Why was AUSA Anne-Marie Villafaña's prepared federal indictment set aside? What role, if any, did the extraordinary composition of Epstein's legal team play in the outcome? And why were the victims kept in the dark? These are not conspiracy theories. These are questions that arise directly from the text of a federal document, from the ruling of a federal judge, and from the findings of the Department of Justice's own internal review. This is not conspiracy. This is court record. The Non-Prosecution Agreement of September 24, 2007 remains one of the most scrutinized documents in the history of American criminal law. Not because of what it prosecuted, but because of everything it made sure would never be prosecuted. The powerful bury the truth, but paper has a longer memory than power. If this episode opened your eyes, hit subscribe and the bell icon, because every file matters. Comment below. Who do you think the including but not limited to clause was designed to protect? I read every single one. Share this before it disappears from your feed. Next file. The work release. You'll hear how a convicted sex offender was allowed to leave jail 6 days a week, driven to a private office by a private driver, and what happened inside those walls while he was supposed to be serving his sentence. I'm Mark Epstein, and I'll see you in the next file.